Stun guns. They're commonly used by more than 11,000 law enforcement agencies here in the United States. But there's a growing debate brewing as to whether stunning a non-violent person is in fact excessive force.
Do anything! Don't tase me, bro! Don't tase me! I didn't do anything! Ow! 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 Ow!
Now, that became a cause celeb. That was a couple of presidential campaigns ago. That young man actually sold T-shirts with that moniker on it, "Don't tase me, bro." Well, now the U.S. Supreme Court is set to hear arguments on that issue. Dr. Yohuru Williams is our legal expert from Fairfield University. And let's talk about that whole use of tasers. Of course, we saw that used during the Rodney King beating years ago. But this has become more of a common occurrence as police officers try to scale back from using deadly force.
Yes, it has, and it's interesting because the court may decide to hear several cases that have come out of the Ninth Circuit dealing with this issue of tasers. And the real issue, as you pointed out, is how are these being used against nonviolent offenders. So there have been cases where people have died as a result of tasing. Those numbers are relatively low. But the real issue is for traffic stops, for nonviolent occurrences, domestic violence disputes, is there a better way for law enforcement to handle these situations without resorting to this non-lethal but nonetheless painful punishment?
And we've heard stories of a pregnant woman who was speeding and didn't want to get out of the car and was tased. There was recently a story about an elderly man whose life alert went out. He was tased, and you know, there is a line. You know, law enforcement has a job to do, and many will argue that, you know, it is non-lethal, and if there's a situation out of control, we try to use our best judgment. To that, what do you say?
Well, it's interesting because the case that you referenced, the pregnant woman, was Brooks versus City of Seattle, which is one of the cases that might be part of the cases that come before the court. And that was very controversial because she was 60 days from giving birth, but she was tased 3 times. So the question here is that, again, is this excessive in violation of the Fourth Amendment? What will be very interesting in this case, Laura, is that Justice Thomas's nephew was actually tased in New Orleans in 2010. And so if the court does hear this, will he recuse himself? Most people think he won't, but he was very upset about that.
Oh, wow. You would think there'd be some bias right there.
There could be,
right,
and you're right, that recusal may happen. But, you know, they've talked about, law enforcement has long talked about scaling back from using deadly force, and that was the reason the taser got so popular. But now we're finding that the taser can be deadly. So, I mean, how do you determine, you know, is there a legal concept that they're using to argue, yes, we can use this, or maybe in these cases, or, I mean, there has to be a science associated with this somewhere.
It's a great question, Brian, and this is another instance where technology seems to outpace our capacity to deal with the issues that it brings up. When tasers were first introduced in the early 90s, this was seen as the solution to things like the chokehold, which resulted in a number of injuries and deaths of offenders. And so the taser was celebrated as a means of subduing people who otherwise the police would have trouble, or it might put a police officer in bodily harm. The problem now is that it's being deemed excessive. Do you need a taser for a traffic stop? Is there another way to deal with those types of issues? And the Fourth Amendment issues here haven't been worked out by the United States Supreme Court, which is why this case could be potentially very important.
Where do police officers stand on this issue?
They love tasers, and for obvious reasons. They have cited statistics that state that 66% of altercations involving police aren't involving injuries of police officers because they had this as a method of subduing offenders. The problem is that police officers face another danger, and that is possible prosecution by virtue of the use of these tasers. Now, in the early cases, the police were able to claim what they call qualified immunity because there had been no ruling by the U.S. Supreme Court on this issue. If the court should rule that this in fact is a lethal weapon or a deadly weapon, that would end qualified immunity, and then we could see police officers' opinions on these change dramatically.
So that would mean they would be more hesitant to use the taser gun or more willing to use a regular gun? What are you saying here?
It would impose more restrictions on the use of tasers. Right now, police officers can use them in a variety of circumstances, and the question from critics has been, you know, what's the line? And it's essentially the same question that you guys are posing. What's the line where police officers say, this isn't appropriate in this circumstance, circumstance, or this might be too much for this case.
It's interesting, you have a different set of circumstances for each different police force because they train differently. But there's something called escalation and de-escalation that police officers use deemed on the situation. And the taser, I remember in California, it was welcomed because now they had something that to go not just use the club, which was obviously an offensive tool, and not shoot someone. So this was a huge thing. But it's interesting to see how the technology, even though it was welcomed, now has become a liability.
Well, again, Brian, great. And the California precedent is a case, Bryan versus McPherson, which was very interesting because it involved a young man who was in a traffic stop. He was distraught. He was tased by the officer, fell face forward, fractured 4 of his teeth and several bones in his face. And again, that raises the question, would pepper spray have been another alternative?
Right.
So again, the weapons are here, but...
You've got beanbag bullets, tasers, pepper spray, what have you. Is it really an issue of the weapons, or is it the person using the weapon?
Great question, Laura, and the Chicago Tribune has actually taken that up today. There's an article in today's Tribune that talks about police get new toys and they want to use these new toys. Clearly, they have been de-escalated certain circumstances, and so the question is this really a question of training? Is it a question of public information, or is it a question of these are dangerous weapons and in no circumstance or very limited circumstance should they be applied?
I mean, because police officers, they have to make spot decisions, and that's what they're trained to do, but the perpetrator also puts the police in a difficult position as well.
Right.
Absolutely, and that's the whole question of escalation here. And again, if there are other alternatives, the irony of this to a certain extent is that when the electric chair was first introduced in the 1890s, it was welcomed as this alternative to a more humane form of punishment. This is a problem with technology. It takes some time to work out the bugs.
Sure.
All right.
And of course, it's all up to the discretion of the police officer, but using it on a pregnant woman, that's a real judgment call.
Definitely.
So, well, thank you for your insight. Always a pleasure to have you.
Always great to see you guys.
We'll see you on the next time.
Thanks.